It's Entertainment Law Update, episode 176 for January 29th, 2025. Hi again, everybody, and welcome to another episode of Entertainment Law Update. From Los Angeles, California, I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And this is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories around the entertainment industry and share our opinions and commentary and analysis and try to have a little fun with it, too. So, Tamara, how are things with you? What's new?
Oh, all is good. You know, if folks missed our previous end of the year episode, I am now a full 3 weeks plus into the new law firm I joined, Harper Bates LLP in Dallas. So super excited to be kicking off the new year with a new firm.
Well, awesome, and congratulations on that. Over here in where I live in Santa Clarita, California, people have probably heard the name of that town in the last week or so, because a week ago, last Wednesday, we had to evacuate our home due to a threat of fire. Fortunately, that fire did not materialize as a real threat to our family and our house, but it was tense and scary. And we were actually originally supposed to be recording last Wednesday, but we had rescheduled for other reasons. And, the evacuation warnings and orders did disrupt our lives a bit, but in the scheme of things, we're doing okay. And I do want to give a shout out after the fires that we've seen here in Los Angeles. I know there are a few friends of the show who have they were affected by the Palisades fire, lost their homes and things. Wow. So I'm not going to call out by name, but we're thinking of you, friends, and hope that you're able to make the most of what's available for recovery and insurance and those kinds of things, and get your lives back on track swiftly and with as little trouble as possible. So,
yeah, and I'm just going to also say, if any of our listeners, viewers, friends, and colleagues work in the music business in pretty much any way, shape, or form, MusiCares, which is the nonprofit organization of the Recording Academy of the Grammys, has money available, and I believe it's a fairly simple process to access the funds that are available for folks who are working full-time in the music business in a variety of capacities. And you do not have to be a member of the Recording Academy to apply and receive funding from them.
Oh, that's great to know.
Yeah, and I know there's lots of other resources available, but that one particular for our friends and colleagues that work in the music industry.
Yeah, and that's a great transition. In our March episode, we will be participating in something called Podcast-thon, where I met this gentleman who launched this in France and Europe a couple of years ago now. But he's rounding up podcasts, all who will, during the same week of the year, participate in asking for donations, fundraising for their charities of choice. And I think our plan is that MusiCares will be the charity we choose for us, and we'll ask anybody who wants to make a donation. You don't have to wait, by the way, until
that's right. You don't have to wait.
but
yes,
musicares.org, I think, is the domain, right? So
right, it's just one C.
Yeah.
So music, ARES, or MusiCares. So it's just one C between music and cares.
So, we
yes, and I know
a contribution.
Yeah, I'm sure on the telecast for the Grammy Awards on
this coming
Sunday
weekend,
night.
Right? Yeah.
Yes, I'm afraid I'm not in LA for all the festivities this year. That information will be broadcast a lot as far as participating, as well as you and I both know there are many other boots on the ground charities available and resources. So,
yeah. So please do donate early and often, as they say. To your charity.
And we can throw a link in here in the show notes.
We will.
We don't have to wait till March either.
That's correct. Right. So
we can add that.
Indeed. Well, it being January, we have a new president in office, and the day before he took office, TikTok just disappeared. It went down for a while, and interestingly came back up. But the ban is our topic of our first story today. The case is called TikTok versus Garland, in the United States Supreme Court, brought up from the DC Circuit. TikTok is this social media platform. You probably know it. It hosts short videos, and it's owned by ByteDance, a company that has Chinese ownership interests and an obligation to disclose data to the Chinese government. Well, the Congress in the U.S. passed a law last April which required TikTok, as well as other Chinese company-owned software services, to be deplatformed and access to the United States stopped in order to secure the data of American citizens on the basis of national security. And if the entities were sold to a company that didn't have those Chinese ownership interests, like an American-owned company or owned by people in the U.S., this would not then apply. And the exact reasoning of for the ban has basically been undisclosed. The public hasn't been told exactly why this is a national security threat. But essentially, the summary is it's just securing Americans' data, just because they're old enough to be on social media, 13 years old on TikTok. It doesn't mean that they won't become president or subject to blackmail or foreign interference later on. And anyway, there's some question about how serious of a national security threat it is. But there are lots of creators in the various segments that earn a living using TikTok, as well as TikTok has its own, TikTok store. And so anyway, a bunch of creators and TikTok itself filed suit trying to bar enforcement of the law on First Amendment grounds. And as the case made its way through the courts, the lower courts consistently ruled in favor of the federal government that national security, I guess, is a compelling governmental interest, and the ban on Chinese ownership is, I guess, narrowly tailored as the thinking on this. And so it made its way. I think
it's more than just the Chinese ownership. I believe the words are control of a foreign adversary, yes, or controlled by a foreign adversary. So it could be more than China.
Yeah.
Because I guess U.S. has a few foreign adversaries. Because I was like, well, what if China sells it to Russia? Oh, foreign adversary. Right. We're still good. We're still good. Okay, I'm sorry. Yeah.
No. So it went to the Supreme Court, and the court assumes in its analysis, without deciding that the law, while having no direct impact on speech, still significantly impacts persons and their speech, making it subject to a First Amendment analysis. Notably, Justice Sotomayor, in her concurrence, argued that existing case law supports the assumption and that it should have been an item in the court's ruling that was more explicitly addressed. Yes, it's a First Amendment issue. So the court determined had to determine whether the law fell under strict scrutiny for purposes of the analysis, and the court said it did not. The reasoning for this is that the law was effectively content neutral, and for a content neutral purpose, intermediate scrutiny is the right standard of review. So Gorsuch, in his concurring opinion, stated that he believes the law would also have survived strict scrutiny, as do I, despite it being a very dramatic, sweeping kind of a law. So they said it's content neutral, didn't prohibit any specific messages, but rather the specific platform and the ownership side of it. So while the court acknowledged that the targeted impact on TikTok, specifically. TikTok is, mints are fine. TikTok is not. So specifically, that alone didn't make it biased as to content of speech. So the purported reasoning for the law being national security, the court said, yeah, that it's still content neutral, a content neutral reason, despite being under inclusive as protecting data with respect to people in other companies from other countries and things. So the data could still be collected, sold, or otherwise transferred, all that. But nevertheless, the holding of the court is that the law is constitutional and the ban is valid. So the immediate impact seems to have been mitigated because the new president, Mr. Trump, issued an executive order on his first day in office to postpone the enforcement of the law for 75 days from his inauguration on January 20th. So TikTok may still go offline in March unless there's been a transfer and divestiture of the company from the Chinese ownership interests. So I
And you
guess, go
can't
ahead.
if you have the app, you can use it.
Yeah.
You can't go download it. And I saw what statement the Apple Store posted. I'm assuming the Google Play Store posted something very similar as it's not available. If you have it, you can use it. And I think if you came in from another country, you might still be able to use it. And I'm sure there are people who have short-circuited around a VPN or something else to get
it was
access. Because the penalties are against the Apple and the Google Play and the Oracle if enforcement really starts. I think it's $5,000 per download, $5,000 per user. I mean, it's a substantial penalty. And I think the other thing the court held was that the law does not violate the petitioner's First Amendment rights.
Right.
So I guess there's kind of this between what the statute is, what the law is, the rights related, and then the rights related to the petitioners being the users of TikTok and the providers, the App Store providers.
Yeah. So, the ban sort of went into effect at midnight on the 19th, and it was sort of the service was back up and running. If you had the app already on your devices, it started working again within, I think, 6 or 8 hours of the initial thing. So, and the news on the web was, oh, the sky is falling, TikTok is down, and all this. I tried to use it. I was traveling on Sunday. I tried to log into TikTok and nothing happened. And then when I got home later that night, it was working. But I have a number of students who had deleted it off their phones for whatever reason. They hadn't used it in a while, and it was off, and they can't re-download
Oh, yeah,
it.
you can't, because mine isn't current on my phone. And I decided today to see if I could. And
to my surprise, mine was still current on my phone, even though I never used the platform. I must have looked at it not long ago. And I was actually posting on TikTok yesterday. So
there you go.
It's still working for me, but we will see. Interestingly, though, the analogy, you ask the question whether or not the First Amendment rights of the users have been violated. And I would say, this is sort of like a community rezoning and no longer allowing billboards in a particular area. Or
that's a good example, Professor Firemark.
Or maybe a bulletin board at your local mall, and for some reason there's a little ordinance that says no bulletin boards in facing the park or something like that. So there may still be bulletin boards. It's just not that one's no longer available for you to post your sign on. But I don't think it really impairs speech in a significant enough way that I think it would pass strict scrutiny on the.
I do too,
and the national security.
And it's unfortunately it's diversification.
Yeah,
for the content creators and talent.
Yeah. Well, what's interesting is the cropping up of other services that are sort of like TikTok. Also Chinese, interestingly, and I presume the law would apply to them as well. It would just take a while.
It does. I believe that's correct because, again, it goes back to what did I say? If it's a foreign adversary, so it's broad enough. I think they mentioned a handful of specific ones, but any foreign adversary. So indeed. Russia, China, it's going to apply.
Yeah. Well, we had Supreme Court action, so that story sort of took priority on the show. But as we always do in January, we like to highlight the public domain. And January 1st of each year is the year that works from, I guess, 95 years prior fall into the public domain. Is that correct? So
yeah. So we're talking works. There's a little caveat, but works published in 1929. Went PD January 1st of 2025.
Yeah, and some of those are pretty famous works of literature. So we're getting to this point where, Hemingway, A Farewell to Arms, exploring the experiences of an American ambulance driver in Italy during World War I. It's been a long time since I read that. I'm going to look at that again. The Sound and the Fury by William Faulkner, modernist literature that delves into the decline of a family in the American South. Virginia Woolf's A Room of One's Own. lecture essays discussing women's access to education and financial independence. So, here we are 95 years later, and I wish the subject was past our consciousness, but it's not. So,
well, right, and we're 95 years later, and these works of art are still
relevant.
American literature that are studied and dissected, and
films from Alfred Hitchcock's first sound movie, Blackmail, the Marx Brothers' Coconuts, their first feature, is also now in the public domain. And on the music side,
wow,
I didn't know that the song "Singing in the Rain" preceded the movie "Singing in the Rain."
I didn't know that either. Yeah,
that song by Arthur Freed and Nacio Herb Brown. And the famous Bolero, Ravel's Bolero. I thought that was older actually than 95 years, but that famous repetitive melody crescendo piece of music. So, what else have we got? There's a few others.
Yeah, so comics and characters, Popeye the Sailor Man. Give me my spinach. Yes, so Popeye the Sailor Man was introduced comic strip in 1929. Tintin, the young Belgian reporter. These are comics. So several of those, as well as, we've already seen in years past, much of the Sherlock Holmes. I think there's some additional Mickey Mouse things that fell into the public domain this year. So that's kind of comics and characters. Be on the lookout again, as we've cautioned, those have changed over the years. So it's only those initial ones that pre-1929 that we're talking about, or pre-1930. The one caveat I had alluded to at the beginning about works falling into the public domain this year is that sound recordings are always a little more special and different in the U.S.
How so?
Because there was no copyright protection for sound recordings, federal copyright protection, until 1972 for sound recordings. So the Music Modernization Act, was that in 2019? Has it been that long ago? 2020? When it passed, it added a 100-year window of protection. So the sound recordings that are falling into the public domain are actually from 1924.
Oh, interesting.
Have become public domain this year. Of interest to me, for a variety of reasons, was that Rhapsody in Blue, as performed by George Gershwin, that sound recording was released in 1924.
Oh, wow.
And is now in the public domain, as well as works by Bessie Smith, Louis Armstrong, Mamie Smith, Jelly Roll Morton, from the jazz and blues eras. So a big swath of sound recordings, as well as classical recordings, Rachmaninoff's Piano Concerto No. 2, Enrico Caruso, various operatic arias. So lots of interesting works that are available now. And I put a link into the show notes to the Library of Congress, where these works, we go, why do we have to send in a deposit copy?
Right.
Well, because the Library of Congress is charged with housing and maintaining and retaining these works. And so they are making public all of the sound recordings that fell into the public domain as of January 1 that they have access to. So all of those 1924 sound recordings will be available for download now from the Library of Congress.
Nice. In case you wanted to use.
In case you wanted to use them. So I've listened over the years. The quality is not always the best, but if that sound is what you need for your production, now you have a bigger access to things.
And with the development of new technologies, AI tools, things like that, it wouldn't be a surprise to hear people releasing new, cleaned up versions of these old recordings that have used AI to, get rid of the pops and hisses and remastering, exactly. And, opening the door to that. So some of this stuff, the Bessie Smith and the Jelly Roll Morton, and even the presidential address from Calvin Coolidge, the first recorded presidential speech those there may be a market for those things. So will be interesting to see. It will be interesting.
Yeah, and I think if people are doing period piece audiovisual works,
right,
this is a treasure trove.
Yeah.
And again, just because it might be available on Internet Archive doesn't mean it's actually in the public domain. But I think we have some really good parameters now for searching and figuring out and determining dates of publication. And anything clearly before 1920 we know is good. Now we're kind of putting this line in the sand of the 100 years. So and I think it opens up some doors.
Yeah, and the Copyright Office does have a good public domain reference page, and there's also publicdomain.org, I think, that does a pretty good job of cataloging works.
And right, and then the I know we have the link to the law school site, where you can go in and you can create your own little calculator. And I can't remember, there was one other work that I had read that had mentioned that, Buck Rogers, the character for Buck Rogers, it fell into the public domain, but it was already in the public domain because I guess it had been challenged and it was not renewed.
Oh, okay.
Yeah. So anyway, you still have to do a little bit of digging to make sure you're correct on that.
And the real trick is knowing when it was originally published
when it was originally published. And sometimes you have to really, over the years, I've worked with a variety of Christian music publishers and Christian record labels. And I have multiple hymnals. And anytime I find a hymnal from late 1800s or early 1900s, I snag it up.
Oh, that's cool.
Because it's really cool because my office is being painted today. So I was cleaning things off the bookshelf last night and I've got a couple of these hymnals, with no front and back cover, but that's pretty good evidence when it was published in precise time with the work. So anyway, I'm nerdy like that. If we haven't figured that
that's a cool nerdiness. I like that. That's fun. It's cool to be a nerd nowadays, apparently, too. My nerdy son seems to get a lot of respect from schoolmates and things. It's kind of funny. So anyway.
Yes. Well, we all know I raised a mathlete.
Yeah. My kid went to school wearing a propeller beanie today, literally. So.
I like it. I like it.
Yeah. Anyway. In other copyright news, we have...
It might qualify as a nerd.
Yeah.
M. Night Shyamalan. Is that right?
An interesting filmmaker and
an interesting filmmaker. Yeah.
So this is a case involving M. Night Shyamalan and his TV show on Apple TV Plus, Servant, that came out in, I want to say it was 2 years ago, maybe 3. He is the executive producer and showrunner of that show on Apple TV Plus, and they were sued by Francesca Gregorini, a filmmaker who made a film in 2013 titled The Truth About Emmanuel. And the claim was basic copyright infringement. Her film involved a mother that treated a doll as a living child and had a nanny who also played along. It was a way of coping with the loss of her child. So she hired this nanny, and it takes this supernatural horror route, as Shyamalan movies are wont to do, where the realistic baby doll starts to act as the focus for the drama and the plot. And there's a cult, and it's implied the babysitter brings the baby doll to life, all kinds of, that supernatural stuff. And The Truth About Emmanuel is a film where a mourning mother uses a doll to cope with the loss of her child, and a teenage girl, believing that the woman is similar to her own mother, offers to babysit and discovers that the baby is actually just a doll. So the argument was effectively that the aspect of mourning woman using a baby doll as a coping mechanism and a babysitter of some sort helping with the process amounted to copyright infringement. And the defendants, of course, argued this is idea, not expression, not protected under copyright law. Also, no access was proven. Shyamalan hadn't seen the film. And this addresses the question of, why dissemination does not equal access, which is something that's important to remember. And Shyamalan also argued that a lot of what was at issue was, stock, I guess you could say savoir-faire, right? A caretaker fainting or something like that. People faint in movies all the time. And in fact, I think while he was on the witness stand, he cited 4 or 5 Alfred Hitchcock movies where a character faints at the sight of something shocking, So
and using a doll in this place of a baby is not
right.
That's an idea.
Yeah.
That is used in many ways, whether it's a scary film or something else.
Yeah.
So
the jury came back with a unanimous ruling of non-infringement. They determined that the plaintiff had failed to prove access despite the film being available on iTunes and those kinds of things. And that was a gating item on the verdict form, so they didn't have to go any further to find whether or not the material that was similar was idea versus expression and so on. So a win for the filmmaker and the platform.
Yeah, so sorry. My brain went to the We Are the Mitchells or Meet the Mitchells that Jennifer Aniston in. Jason Sudeikis movie.
Oh, yeah.
Where they have a fake baby with the drugs. So anyway.
I'm feeling faint. Okay. Do you know what a moke is?
So interestingly enough, I did not. So I took a very structured survey of party of one in my house and asked, and they didn't know what it was either. Is it a moke? Is it a mokey? I don't even know how you say it.
We had the same experience on the team call the other night when we were sort of finalizing the download. Nobody really was familiar with this term, but the company Moke America LLC,
M-O-K-E, right?
Suing Moke International Limited. Moke LLC and Moke International Limited both claim rights to the trademark used for their low-speed open-air vehicles. So these are sort of like golf carts. They look a little more like the design of a Jeep, but it's a low-speed open-air thing. So Moke America said that it had acquired certain common law rights from a now defunct company, while Moke International concluded that the mark had been abandoned and that it held priority because both of these companies are making these things and calling them Moke. So the U.S. District Court, I don't have a list of what court it is. It looks like it's the Fourth Circuit. Oh, so anyway, the district court ruled that Moke had become a generic term for this category of vehicles, and both parties went up and appealed. So on appeal to the Fourth Circuit, the legal issues were, one, whether the term Moke had become generic, and the court looked at whether it was perceived by the relevant public as a generic term for open-air recreational vehicles, and that would render it ineligible for trademark protection. And two, determination of trademark priority. The court needed to establish which party's rights were superior. If it was eligible, then which party had the superior rights. So the Fourth Circuit took it up and reversed the lower court's ruling and found that Moke had become generic. The appellate court concluded that the evidence didn't demonstrate sufficiently that the relevant public primarily understood the term as a generic term. So in reaching its decision, the court referenced a precedent from Kellogg versus National Biscuit, which outlines the standards for determining genericness. And the standards are, one, primary significance to the public, and the court emphasized that the primary test is how it's understood by the relevant public. And if the public primarily understands it as identifying a category of goods rather than a specific source, then it's generic. Also,
and they gave the example shredded wheat.
Yes.
Did anybody know that shredded wheat at one time was a registered trademark? The cereal, just in case.
I would have actually thought it still was, but that's me. Historical use and context. The court examined the historical use of the term and whether it originated as a brand name or as a descriptor. That's where the example shredded wheat came up. Wheat that is shredded and not inherently associated with a single producer. Also, third factor, common usage by competitors. It's going to be likely to be generic if used by competitors to describe their own product. That's sort of, they're infringing, so it must be generic, is what that sounds like to me. But
right.
And then for a lack of secondary meaning. If a term hasn't acquired a secondary meaning, that the public associates that term with a particular source or producer, then it's more likely to be generic. The court in this case found no evidence of that association. And functionality and fair use is another factor. The court looked at the need for competitors to use common descriptive terms to fairly describe their products. And they noted that granting exclusive trademarks to those terms would hinder competition and create unfair monopolies on ordinary language. I don't know. I don't think moke is ordinary language, and maybe you and I just aren't the right market for these things.
Yeah, maybe we're not.
Yeah.
Yeah, the consumers of that, but I had never heard of it, and maybe if I'd gone and looked at it, that would have
so not generic,
me. I don't know.
To the Fourth Circuit. Which then also remanded the case to the district court for further proceedings to figure out which party has the priority on the trademark, to assess the validity of Moke America's claim of acquiring common law rights and to evaluate the abandonment and subsequent priority kind of questions. So they emphasize the importance of establishing clear evidence of use and recognition in the U.S. market. I wonder what happens if neither of them can show big recognition in the market. What if it's sort of equal?
Well, then I think, I don't know, and can the court determine who the senior user is, who has priority?
Yeah. Yeah.
And I don't think it's unusual for, there are many brands that can be abandoned. Mm-hmm. And it's more than just the trademark application being abandoned or canceled. I mean, you have to confirm it's not being used. And again, I would say it doesn't have to be used around the world. It would be used in the U.S. Mm-hmm. You might have trouble if you're the junior user trying to enforce it outside the U.S., which this has kind of got a lot of those little intricacies in there. I'm sure this is going to get settled before we get a court ruling, but maybe not. So,
all right, who wants to take bets? Tamara said it's going to settle, so we'll have a full trial.
I think it's going to settle. Yes, that's right. I'll be wrong, and we'll have a full-blown trial, and we'll be talking about it in 5 years. So,
yeah, really. Anyway, it's sort of interesting, and I always thought moke was sort of a pejorative term used for someone who is kind of a schlub, not all put together, and down on his luck and those kinds of things. But what do I know?
That's probably not what they want attached
right?
to the description of the product.
Anyway.
Oh, my gosh.
What do we know about – are you a South Park fan?
No, we're going to get hate mail, aren't we? I don't even know if I've ever sat down and watched a whole 30 minutes of South Park.
I have, but it's been a long time. I was sort of surprised to know that in 2019 it was still
it came back.
Produced.
Yeah. That it returned or whatever may have happened on that.
Yeah. Well, go ahead. You want to take this one?
Yes. No, I got it. Sorry, I got too many things ringing that I should have turned off before we started. So a New York court has ruled in favor of Warner Brothers. This is Warner Media Direct versus Paramount Global, South Park Production Company, MTV, and so on and so forth as the defendants. The court ruled allowing a lawsuit against Paramount to proceed to trial. This was on a partial motion for summary judgment related to a variety of claims that had been brought, but it stems from a dispute from a 2019 licensing agreement in which Warner secured exclusive U.S. streaming rights to South Park for their HBO Max channel, reportedly a $500 million deal. It's important to note, I think, from a drafting and advising perspective to our clients, a practice pointer, as we often throw out, is this was what's called a binding term sheet. So it is a binding agreement, but it did not drill down and spell out everything that might have been developed into a more robust, fully executed agreement. So on this binding term sheet, Warner is alleging that Paramount breached the agreement by diverting certain new South Park content and episodes. It was a 2-season deal in which Warner assumed that they would get 10 new episodes for each season, and they would be of a certain runtime, a certain length. And so that's the assumption they're working under the agreement. And come to find out, Paramount went forth and produced some specials and other content related to South Park that they allowed to stream on Paramount and or sister streaming services, instead of providing those to Warner Brothers under what Warner says is part of this term sheet and a binding term sheet and agreement. So Paramount has denied the allegations of breach of contract, unjust enrichment, and a variety of other things, including torturous interference, and saying it's fully complied with the terms of the term sheet. And they say that this additional or new South Park content in question, one of which was, I think, a COVID type special, falls outside of the original deal, arguing that the specials are new programming and should have been separately negotiated. And they were separately negotiated with MTV Entertainment Studios, a division of Paramount, for their broadcast. So I think this is something we need to look at as we're doing deals for legacy content. What exactly are we acquiring? And who can use something else? Is it an exclusive right or a non-exclusive right? And maybe it was an exclusive, I don't know the terms of this, but let's say it was an exclusive deal for content for 2 seasons of a certain length, but they didn't agree to the number of episodes. And they didn't block, what I would say is competitive content being broadcast or streamed somewhere else.
Yeah, or they use ambiguous language, like they refer to series episodes when there's other content that's not an episode, like a special or something like that.
Yeah.
Those kinds of ambiguities. We all know that that's what lawsuits are made of, right?
Right. So, and my first thought as I'm reading this is, well, what about the 4 corners of the contract? Mm-hmm. Well, the court says ambiguity of the term sheet, parole evidence will likely be necessary. And this is me summarizing, and, we haven't done enough discovery to figure out what that parole evidence is. So the court denies the motion for summary judgment. And that was just as to the issue of unjust enrichment. It's an interesting read as far as how overlapping these causes of action are, because as you and I both know, you will almost always see this scenario: an unjust enrichment, a breach of contract, and potentially a torturous interference. While I don't believe there was not a copyright infringement claim, many times that's thrown in as well. So how these overlap and, what is your recovery when these are very similar. So I don't know. Settle, not settle. It's going back for more discovery, that's for sure.
Yeah. And maybe trial, maybe, as you said, maybe settlement. You can make a prediction on that one too?
No, I'm not going to make a prediction on this one.
Maybe we
I don't think the studios. I don't think the studios like to.
They don't want to let judges and juries decide their future.
That's right.
Yeah, so they settle so that they don't have adverse rulings on the record. Well, interesting.
And would it make a difference? I don't know, in the facts, if Paramount had licensed this footage not to a related entity.
Oh,
interesting. So it feels like, was this a fair deal? Was this a fair handshake?
Yeah, well, $500 million deal is nothing to sneeze at. And the legal and business affairs folks that worked on it, I'm sure, thought they were doing things,
That's right, that they had it nailed down, yeah.
But at some point, a term sheet is supposed to be a term sheet while you work out the nitty gritty of the long form deal. And it doesn't sound from the facts of the case like they ever tried to get it to a long form deal. It's not like they later, after the episodes started being delivered, they had a disagreement about things. They just never did the long form. And
and we don't know. That may all come out in depositions as to. Yeah. And timing wise, maybe this was a COVID deal.
Could be, yeah. Could be that people having to work from home or being laid off and it just slips through the cracks. Who knows? But,
yeah,
I mean, it's not unusual in the Hollywood industry that deals or, the deal is papered long after the film has been released or something like that. So it may also just be a sort of a casual attitude and approach. Again, we don't know who the lawyers and business affairs folks were, but, it may be sort of custom and practice in the trade articulated how this was going to go down, and here we have evidence of why that isn't always a good idea. So, we shall find out more in the fullness of time, I'm sure.
Yep.
Next up, we want to move into the AI corner a little bit here and talk about this music AI issue or case that came up. The case is Concord Music Group and others versus Anthropic. Anthropic is the creator of the Claude AI tool, as well as some others. And this is the first action taken by a music publisher against an AI firm over use of lyrics in a large language model. 3 major music publishers that are suing Anthropic over the use of lyrics to train its AI system have arrived at a deal with the company, which is backed by Amazon, by the way, resolving some parts of a pending preliminary injunction. It's Universal Music, Concord Music, and ABKCO, and other music publishers suing in Tennessee federal court starting back in October of 2023, accusing Anthropic of copyright infringement for training its system on lyrics from at least 500 songs, artists like Katy Perry, the Rolling Stones, Beyonce, and so on. One example, when asked the lyrics to Katy Perry's song Roar, which is a Concord-owned title, Claude provided a near identical copy of the words in the song, according to the complaint. At the heart of the suit were the allegations that there's already an existing market that's now being undercut by Anthropic using these lyrics without consent or payment. And the publishers pointed to lyric aggregators and websites that do license the content. So, settlement agreement in place now, I guess. Anthropic must maintain its existing guardrails to prevent the chatbot from providing lyrics to songs owned by these publishers and not create any new song lyrics based on the copyrighted material. The publishers can notify Anthropic that the guardrails aren't being effective in preventing output that reproduces and distributes or displays the stuff. Publisher, creates derivative works based on those compositions. They can give a notice, basically. Okay. Kind of similar to the DMCA approach to things, right? And Anthropic will respond expeditiously and undertake an investigation, which there will be cooperation on both sides.
And I tested it this morning.
Yeah.
So I went in and, thinking I'm smarter than the large language model, I didn't even say, tell me the lyrics. I said something like, hey, I can't remember the words to.
Oh, interesting.
And then I inserted the song title, can you help me? And it spit back out. I understand you're asking for the lyrics of insert song title. Mm-hmm. I can't reproduce those lyrics, but let me tell you what I know about the song.
Oh, okay.
And it said, here's the songwriters, it went to number 1 on Billboard. It gave additional information about the songwriters and the song, but it said, and I know for a fact this song is not part of the companies that sued.
Oh, interesting. Okay.
So I thought that was interesting. There was a guardrail up. And in the past on other large language models, I've asked, didn't do it today, but I've asked for the lyrics of this song and it's given them to me.
Oh, interesting. Okay.
And I thought NMPA, National Music Publishers Association, had brought suit against ChatGPT, but then I couldn't find anything I
Yeah,
guess there's just been lots of conversations, but maybe this is the first lawsuit brought by music publishers against a large language
I think
model.
NMPA might have been a party in this case also. I thought I saw something about that, but I didn't go look at the caption.
I bet they are. Okay.
Anyway, so the court will retain jurisdiction to resolve future disputes relating to this stipulation. And, Anthropic's position is we put up these guardrails. It's unlikely any future users will be able to use these tools to get lyrics that way. There's technical measures and other things at all levels to prevent users from simply prompting Claude to regurgitate the training data. So they said, look, Anthropic isn't designed, Claude isn't designed to be used for copyright infringement. And the stipulation they claim, the public statement is that it's consistent with these priorities where we're trying to do the right thing here, basically. Anyway, so the case is still moving forward, and the fair use defense is certainly going to be a big factor in it as things move forward, along with all the other AI cases, I'm sure. And the court will eventually decide whether to issue an injunction to bar Anthropic from training future models on lyrics owned by the publishers. So we will know more again in the future. Interesting.
Yep. So we've talked about this Minnesota deepfake statute, right? Last year?
I think we mentioned it when it was proposed. Yeah.
Okay. So it's Minnesota Statute 609.771 prohibits, under certain circumstances, the dissemination of deep fakes with the intent to injure a political candidate or influence the result of an election. So I didn't know you could bring, but two plaintiffs have brought a pre-enforcement challenge to the law, and the court denied their preliminary injunction.
Okay.
Yeah. But yeah, Christopher Coles uses AI tools to create what has been alleged as right-wing propaganda content, as well as Representative Mary Franson, who shares this propaganda. Mm-hmm. And the court says the statute does not penalize, quote, pure parody or satire. Okay, I have lots of questions about that. Mm-hmm. And Cole's deepfake videos are constitutionally protected as parody, emphasizing that they were clearly labeled as parody. Gosh, if I had known labeling something as parody made it parody. And includes disclaimers stating the sound and visuals were significantly edited or digitally generated.
Well, boy, parody. I mean, two things there. One, labeling something as a parody kind of takes the wind out of the sails of the parody, right? Because it takes the fun and the surprise out of it. But also, just because the creator labels it parody doesn't mean it actually is a parody.
And I think that's where this hopefully moves forward to.
Right.
The decision effectively establishes a mandatory disclosure requirement for deep fake content. Okay, I think that's a good thing, but where labeling something as, quote, parody provides legal protection, regardless of whether it truly qualifies as parody under traditional legal standards.
The court said
I don't think labeling it a parody tells me it's a deep fake. I don't see how
calling it a deep fake might, again,
but let me know it's a deep fake.
Yeah, but I guess you could do a deep fake. It's still false. It could be defamatory. There's all kinds of other things. The copyright side, well, no, it's a deep fake law. So I don't buy it. This was a preliminary injunction phase of a case, right? So there will be more to talk about.
Right. I think there's got to be, I like the intent of protecting consumers from deep fakes. Mm-hmm. I don't think saying put parody on it protects me, because as the average Joe consumer, as an average Joe consumer doesn't even know what a parody is. They think anything that's making fun of something is a parody. But you and I both know by definition under the copyright that is not the definition of a parody. Yeah. So They got to come up with something new. Now, here's maybe the practice pointer of the day. Stanford professor Jeff Hancock submitted an expert report supporting the Minnesota's deepfake law. It was discredited because he used generative AI to help draft it, and the AI fabricated a citation, which was an error, and he failed to catch it before he submitted his expert report. The court rejected his request to resubmit a corrected version, emphasizing the irony of an AI expert becoming a victim to AI misinformation. Well, this is an assumption, but I think we can probably make this assumption. The ruling severely damages Hancock's credibility with with the court highlighting the importance of verifying AI-generated content.
I would say the state of Minnesota is looking for a new expert witness for this case as it moves
I
forward.
think they are. I think they are. Oh my gosh, that's just scary. You know, I mean, we all make mistakes.
Well,
but we got to be careful about that.
I mean, yeah, and and it's more than a practice pointer. I would say this is a standard of care.
It is
a standard of the duty of competence, I guess you could say. If you're using AI for any purpose at all, you've got to check every word backwards and forwards because you can't unring that bell. This guy's credibility, at least with this case, this court, is severely damaged. And I would say maybe even in future cases, this gets cited as, hey, didn't this happen to you? Put him on the witness stand.
Right.
It's a step in the direction of impeaching the witness. So I'm not a litigator, but that seems pretty obvious to me. So
right. And I think it's just tough. I mean, we early on heard the cases of the associate attorneys.
Yeah.
Who the partner was not reviewing the content, and it gets filed, and then you have someone at a much more established level gets caught in the same snare on AI.
Indeed. Well, let's talk about this DMCA case. The case is called Loper Bright, and I don't have the full caption here, but you may have heard the folklore, I guess, not the folklore, it's a fact that the ice cream, soft serve ice cream machines in McDonald's stores would often be out of service. You'd go ask for the ice cream and they couldn't do it, and they were waiting for the repair service to come and deal with it. And a lot of times that was because the DMCA was being used as a way of protecting, I guess, the software in the machines that would maintain the various status of things. And so nobody was allowed to repair these machines except for the authorized manufacturer's representative repair service. And those were few and far between. So again, the DMCA prohibits the circumvention of technological measures and effectively, that are used to effectively control access to a work protected under the Copyright Act. And so it was a violation to go in there and circumvent descramble or decrypt the encrypted stuff in order to avoid or bypass or remove or deactivate or whatever. And McDonald's machines were subject to these kinds of protections against just anybody coming in, and I gather it was to actually read the error code data and figure out what needed to be done to fix it, as well as implementing the fix. So the Copyright Office has implemented a new exemption to enable these kinds of repairs to the ice cream machines, so that now the owner of a franchise can figure out how to get it, or it can bring in another repair service and so on. So the Copyright Office specifically determined that the prohibition against circumvention of technology measures to control access and copyrighted works doesn't apply to persons who engage in non-infringing uses of certain classes of copyright works, including, but not limited to, and there's a list of categories: motion pictures, television shows, videos, literary works, excluding computer programs and compilations compiled specifically for text and data mining purposes. literary works consisting of compilations of data generated by medical devices or their personal corresponding monitoring systems.
Oh, okay. So you
your
have a
insulin pump or
textual work,
Yeah.
a printout of that work. Okay.
Computer programs that enable wireless devices, smartphones, smart televisions, land vehicles, marine vessels. So this is sort of that. It's a right to repair exception.
Yeah, it's so when you take the car and you have the mechanic put it on the rack and it's like, oh, it's error code, whatever, they can work on it. Okay.
Yeah, and not have to maybe buy the software from the manufacturer for that analytics tool or whatever. So that analysis tool. So, so there it is. That it's a basic exemption. The question is, how far is this going to go? What's going to be the scope of this? Because it isn't including but not limited to when you talk about these non-infringing uses. So I think we're back to what's the word? The Betamax decision. It's capable of certain non-infringing uses. Therefore,
yeah. And I just think it's interesting, McDonald's is the one that makes the makes the case law or makes the change in the ruling. But that really does make sense because Joe's Garage is probably not that concerned about figuring out the error code and repairing my car. A franchisee of McDonald's is probably concerned about bringing somebody in to repair the McFlurry machine. So.
Right.
Yeah.
Well, and I wonder, was it McDonald's that was behind this, or was it some local franchisees that got together?
I don't know, but I guess just saying they're the ones kind of.
Yeah.
The law is based.
I don't think McDonald's is the maker of the machine, and so I think it's.
Yeah, probably not. But I'm assuming it's because franchisees just didn't want to run the risk.
Yeah. Well, and if McDonald's had an interest in protecting this stuff, this ruling might have gone, it was probably lobbying in the Copyright Office.
Yeah, could be.
The interesting thing for me is just a quick question about this is after the abandonment, or not the abandonment, the overturning of the Chevron deference thing in giving administrative agencies deference for their rulings. I wonder if this Copyright Office making rules like this is going to have any impact, or if litigants are still going to come in and say it's still a violation of the DMCA. We don't care what the Copyright Office says.
They're putting it into the Federal Register. Does that make a difference?
But that's how administrative agencies make their rules.
Oh, right? Okay.
So I just find myself wondering if the follow-on effects of that abandonment of Chevron is going to take the ability to make rules away from, the ability to effectively make rules away from agencies like the Copyright Office and the Patent and Trademark Office and things like that. Are we going to see more litigation of decisions that we normally would have just sort of accepted from these agencies?
I don't know. Interesting.
Time will tell. Yeah. What is this about AI works protection of?
So where are we, I guess, is the current question as to a work that has been created. I kind of don't even want to use the word created, but created predominantly through AI model. So in 2002, the U.S. Copyright Office denied 2022. Yeah, 2002, they would have been way ahead of the game. But in 2022, there you go. The U.S. Copyright Office denied Jason Allen a copyright to his work that was entitled Theatre d'Opera Spatial. It was a visual work created predominantly through inputting about 624 different text-based prompts into the program Midjourney. The Copyright Office denied the copyright registration because of lack of human authorship, which is a requirement for copyright protection. Allen rebutted the human authorship test, saying it was misapplied, that use of AI should be considered similarly to other tools available to artists to help them create a work. Copyright Office, nevertheless, has maintained its refusal of the portions of Allen's image that were generated by the AI tools and noted Mr. Allen had no control over how the artificial intelligence tool analyzed, interpreted, or responded to his prompts. And he did not exercise any control over the actual creation, development, or execution of the image that the Midjourney program rendered onto the screen. Allen recently sued in Colorado federal court to reverse the U.S. Copyright Office decision. He seeks to obtain a declaratory judgment stating that his work is eligible for copyright protection and to overturn the U.S. Copyright Office's decision and obtain a registration, and to clarify the legal standards surrounding works created with AI assistance. Okay, so he's not the first one that the Copyright Office has refused. We had the other work.
Yeah.
Where part of it was registered, part of it was not registered.
Zarya of the Dawn or whatever it was called.
Yes, yeah.
Yeah.
Allen's got to define what he's trying to protect. He's represented by counsel, Dunlap, Bennett, and Ludwig. Is that correct? Ideas cannot be copyrighted, so it's got to be the physical form of what he's trying to protect. And it needs to be original work of authorship. I mean, fixed into a tangible medium of expression. So I think the questions become, how is he going to meet the definition of an original work of authorship fixed into a tangible medium of expression that is required to have human authorship?
And here again, challenging an administrative agency's decision, does the court give any deference at all to that administrative agency's policies on these kinds of things, or does it decide these things de novo?
Right. And I don't know when the human authorship requirement showed up in the compendium.
Yeah.
It was well before the apes.
No, I think
but we've talked about this in the last 5 or 6 years, that there was some clarification to the compendium that added language.
So, I mean,
related to the decision. So,
yeah. Well, I think this Loper-Bright decision has very far-reaching consequences. This is the abandonment of the Chevron deference that I was talking about.
okay.
Copyright Office compendium is an administrative policy document that may or may not have any relevance in a court case. I mean, I guess it could be persuasive authority, even if not deferred to. And likewise, the manual of examining procedure, could that be viewed as it's just some ideas from some functionaries over there, the bureaucrats, but the courts can do what they want to interpret the law and disregard those things? Is this the dismantling of the
law
state?
and the changes in the law can shape and does shape what content is in the next edition of the Trademark Manual of Examining Procedure and what's in the next edition of the Copyright Compendium. There is an interplay between reality as to what's happening, but we've got to have some kind of guidance to understand how to implement a few lines out of the Constitution
right. Well, and out
into
of the
our
statute.
practice.
Congress makes a law.
And out of the statute, right. I mean, the statute is that big. The compendium is that big.
Right.
So
yeah. So I just have concerns that we're basically saying we don't care what these government agencies have said. We, the courts, the Supreme Court and down, are going to decide these things without a lot of reference to that. And, I guess it's certainly a way to go. I think it's going to put an incredible burden on courts if people start challenging these administrative agencies more than they already do. So, the Chevron thing was an environmental law, I think, and it
I guess I need to go back and kind of reread that for purposes of what you're saying as to how far can that extend.
Base, but my understanding is that prior to Loper-Bright, courts were required to give substantial deference to the determinations of various administrative agencies, the EPA, and in the particular case of the Chevron. And so it was the right case for the anti-administrative agency folks to bring up to the Supreme Court. But I think the consequences of it will trickle down to these other agencies that are, less controversial in the eyes of the public and yet make decisions that affect you and I on a regular basis. So this is, I think, where we're going to be watching the next couple of years at least.
For our law student listeners, there's your law review paper.
You're right.
Right there.
There you go.
That is such a law review paper.
Okay. I'm sorry.
No, yeah, I know. And then I'm just going to throw into that, as we started the conversation talking about the Grammys and we're coming to the close and we're talking about this, is just to say, law students, it's too late for this year, but the Recording Academy always has a paper competition in the fall. And the grand prize is an all-expense-paid trip to the Grammy Awards. So anyway, be thinking about that, and you could potentially come up with some creative paper based on the Chevron case and how it might apply to the music business. So anyway, just throwing that out there.
And with that, we have arrived at the end of another episode of Entertainment Law. I thought this was going to be a short episode, and here we are, over an hour again. We somehow managed to fill the
We just got
time.
So much to say up here, so, got to get it out.
Yeah. Anyway, as always, I say a big thank you to our loyal listeners for spending your time with us. The best way you can help us and pay us back is tell your friends, spread the word about the show. We'd love to have more folks listening and hopefully learning from us, maybe disagreeing with us. Share your feedback, and we hope that you have feedback for us. Leave it on the voice widget on the website at Entertainment Law Update, or just an email to entertainmentlawupdate@gmail.com, or reach us through our various social media channels. And Tamara, why don't you tell folks how to reach you?
Yeah, so you can find me at createprotect.com. That'll take you to my longtime website blog that I've been using for years. You can find me, my new firm is harperbates.com. On most social media, I am at Tamara Bennett, TAMERABENNETT.
And I'm Gordon Firemark from Los Angeles. The website is at firemark.com. You can also find gordonfiremark.com. Different websites, but same stuff, similar stuff. And my YouTube channel is doing quite nicely. So find me, G Firemark, on YouTube and most other social media websites. That's the handle. A big shout out to our team of volunteer contributors. Managing editor John Janicek has been with us a good long time, and we love the help that you give us, John. Charles Thorne, Alexis Allen, Violet Zhang, Tasha Spear, and Dawson Holder all also contribute to our shows. And if you are interested in becoming part of our little family of ELU contributors, reach out to us, entertainmentlawupdate@gmail.com. Send a cover note and a resume, and we'll circle back with you. And I think that is going to do it for this episode of Entertainment Law Update. Thanks again for listening. And until next time, hey, that's showbiz. See you soon.